Good morning, good afternoon, or good evening. This is Pamela, and you are watching Pam Entertainment TV, where we review movies, television series, and incidents in pop culture to see how those incidents may or may not affect our daily lives. Listen, child, housekeeping. Please if you like what you see, please hit that like button. Also, if you do like what you see, hit the subscribe button. And once you subscribe, you'll be open to a plethora of movies and television series that I have reviewed. Also, you will be opened to my pop culture chats and my celebrity legal news. Yeah. We are here. We are here. You see the title. The judge told Jay-Z, boy, bye. Motions denied. You got too much dip on your tip, Jay-Z. You ain't following the procedures. Saying that he's not following the procedures, but you're not following the procedures as well. And we about to deny your stuff, okay? So boy, bye. Go on back in there and do what you have to do. When you file your motions, file them correctly and proper and organized, and keep it moving. So let's go over this. I have a couple of articles, and I have the judge's information that we're going to read. Let's see. I just want to I can't choose which article I want to read. Cha cha cha. Uh, choices, choices, choices. All right, so let's read what is this? This is the Daily Beast. Let's read what the Daily Beast says. Let me present this to you all, and then we'll read the Daily Beast, and we'll read the exact order. I have another article from the New York Post, but I just like the headline on this one. It's written by Hugh Daughtry, and it says Jay-Z and lawyer brutally slapped down by judge in teen rape case. Ooh-cha. The star lost round one of his bid to end a claim, which I don't understand how he said this thing, but I'm not going to read it because I don't understand how he's written it. Let's continue. It says Jay-Z and his hard-charging attorney were handed a setback Thursday by the judge overseeing the claim that the star SA'd a 13-year-old girl at a Diddy party. The billionaire rapper named Shawn Carter had his bid to name the now adult accuser denied. He was given until the middle of January to file a detailed response to her allegation, which he has publicly and bitterly denied. Also targeted by Judge Annalise Torres was Alex Spiro, the high-profile and pugnacious attorney Carter has retained to fight his case. The judge tore into Spiro for relentless filing of combative motions containing inflammatory language and ad hominem attacks. She warned him his conduct was inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. Spiro has also acted for Elon Musk's Alec Baldwin and currently represents the alleged corrupt New York mayor Eric Adams. The defeat in this first round of litigation marks a setback for Carter, 55, who has lashed out in public after her allegations, calling them idiotic and saying that he is heartbroken that his wife, Beyonce, will have to tell their children about the allegation. The woman alleges that she was SA'd by Carter at a party run by Sean Diddy Combs after the 2000 MTV Video Music Awards in Manhattan, New York. The woman first accused Combs of spiking her drink, R-ing her in a suite in October. A suit filed in October, then last month added to it by naming Carter. The plaintiff, identified as Jane Doe, tried to get into the VMAs, and they outlined what's going on. And it says, according to the complaint, the driver told her she fit what Diddy was looking for. So Let me go down here because we're not going to just go back and reread all of that. In December, Carter pounced on an admission the woman made to NBC News, which admitted inconsistencies in her account. I have made some mistakes, she told the site. In court filings, Carter said the admission was evidence that her case had no factual basis whatsoever and strengthened his case that the woman be named. But in her Thursday ruling, the judge concluded that for now, the woman will remain a Jane Doe, although she said that could change nearer the trial. Carter has denied that he was friends with Combs, whom he was photographed with numerous times over the years. Spiro say the two has had no long-time bond and told NBC just because they know each other, that doesn't mean anything. How the civil case against Carter will proceed remains unclear because it's part of the case against Combs, who is first facing criminal trial on charges of uh, ex trafficking, uh, SA, which could see him die behind bars if found guilty. Combs is vehemently denying all charges and is awaiting trial in the quote unquote hellhole federal lockup in Brooklyn, New York. All right. So let's go over what the judge actually said. So here is, let me make sure that you all are seeing it like I'm seeing it. All right. Here is what the judge said. And this is Annalise Torres, a district judge. Plaintiff Jane Doe filed this action on October 20th, 2024, alleging violation of the New York City Victims of Gender Motivated Violence Protection Act, NYC, Admin Code 10-1101. By order dated November 6, 2024, the court provisionally granted plaintiff motion to proceed anonymously, explaining that defendants had yet to appear in this matter and that the balance of interest weighing for or against anonymity may shift as her suit continues. On December 8th, plaintiff amended her complaint to add Shawn Carter, known professionally as Jayz, as a defendant. Plaintiff again sought to leave to proceed anonymously, EF number 32, but this time Carter's counsel appeared and moved to deny her motion, or in the alternative, to dismiss her amended complaint pursuant to Federal Rule of Civil Procedure 12B1 ECF numbers 36 through 37 and 40. Carter also moved for an expedited hearing on the issue, EFC number 41. The next day, Carter's attorney filed a letter containing a declaration from an associate in his law firm recounting a phone conversation she had with an unnamed woman who claimed that plaintiff's counsel encouraged her to lie about her experience of sexual SA. Sorry, EFC numbers 42 and 42-1. Carter's lawyers asked the court to consider this additional information in connection with plaintiff's motion to proceed anonymously. Plaintiff's counsel denied Carter's allegations against him. On December 13th, 2024, Carter's attorney filed an additional letter alerting the court to a recently published interview of plaintiff on NBC News. In the interview, plaintiff speaking anonymously, explained her allegations against defendant and her reasons for coming forward now. Carter's lawyers points to the interview in which plaintiff admitted to inconsistencies in her story as evidence that plaintiff claims have no, quote, no factual basis whatsoever. He also argues that plaintiff's counsel violated Federal Rule Civil Procedure 11B by, quote, failing to undertake a reasonable inquiry into the facts before filing the complaint and failing to seek admission pro hac vice to this court. Carter's attorney requested an expedited briefing schedule for a motion to strike the First Amendment complaint under Federal Rules of Civil Procedure 11C2 and 12F. The next day, Carter's counsel submitted yet another filing, a motion for an emergency order directing the preservation of evidence and striking the amended complaint under Rule 12F ECF numbers 47 through 49. Okay, number one, Motion to proceed anonymously. In deciding whether a plaintiff may proceed anonymously, court balances the plaintiff's interest in anonymity against both the public interest in disclosure and any prejudice to the defendant. And the Second Circuit has laid out a non exhaustive list of factors to be considered. And they list these down here. It says a court is not required to list each of the factors or use any particular formulation as long as it is clear that the court balanced the interests at stake in reaching its conclusion. Here, the weight of the factor tips in favor of allowing the plaintiff to remain anonymous, at least for this stage of the litigation. Factors 1, 2, 4, and 7, whether the litigation involves matters that are highly sensitive, whether the identification poses a risk of retaliatory or physical or mental harm, and whether the plaintiff's identity has thus been kept confidential, weigh strongly in favor of anonymity. In her amended complaint, plaintiff alleges that defendant drugged and AR'd her when she was only 13. Courts in this district have recognized allegation concerning SA are highly sensitive and of an extremely personal matter. And it lists the different cases. Plaintiff is particularly vulnerable to the possible harms of disclosure. According to her amended complaint, she continues to experience depression, post-traumatic stress disorder, and a seizure disorder associated with the stress of her essay. Let's see. Moreover, plaintiff counsel asserts that many of his other clients who have filed similar lawsuits against Shawn Combs claims to have been threatened by Mr. Combs for their decision to speak out. And finally, although plaintiff sat for an interview with NBC concerning her case, NBC allowed her to conduct the interview anonymously. Granted, several factors weigh against allowing plaintiff to proceed anonymously. Plaintiff is challenging the action of private parties, not the government. And given the media attention surrounding this case, the public has a substantial interest in this litigation, separate and apart from its general interest in an accused being able to publicly confront an accuser. Alternate mechanism may exist to protect confidentiality, name, the redaction, and sealing of documents. So nevertheless, she's going to keep it anonymously. And then the remaining motions. Now, this is where the judge basically said, boy, bye. And before we get to that, there was something that I wanted to look up real quickly. Give me one. So it was the pro hoc vice is a legal practice that allows a lawyer to participate in a case in a jurisdiction where they're not licensed to practice. The term is Latin for this occasion, for this time only. Here are some things known about pro hoc vice. To appear pro hoc vice, a lawyer must be in good standing and have an active license to practice in another U.S. jurisdiction. They must also associate with a local lawyer who is a member of the bar of the jurisdiction where the case is being heard. Local counsel acts as an anchor to the bar of that foreign jurisdiction and can be held liable for the actions of the pro hoc vice lawyer. So basically, they need a lawyer in the jurisdiction that they're not licensed to practice to be the quote unquote anchor. In other words, to be their way in. And so that anything that they say or anything that they do, this pro hoc vice lawyer, the anchor lawyer, will be held liable for any of those actions. So there may be fees associated. The American Bar Association model rules of professional conduct requires lawyers to consult local counsel when advising clients outside of their practice jurisdiction. Okay. Because I needed to know what that was because people were making such a big deal about that particular thing. So now we know why he was making why Spiro was making such a big deal about this pro hoc vice. So let's go on. So, in other words, I've read all of that, and basically the judge says, boy, bye. She's going to stay anonymous, and there's nothing right now that you have given to me that's going to make that any different. But the judge also said that as this case goes on, it may be that the plaintiff may be identity may be released by the court. So let's get back to what I was remaining motions. Since Carter's attorneys first appeared in this case 17 days ago, he has submitted a litany of letters and motions attempting to impugn the character of plaintiff's lawyer, many of them expounding and on the purported urgency of this case, describing plaintiff's counsel as self-promoting and accusing him of extortion. Requesting to be heard on an expedited basis and accusing plaintiff's counsel of exploiting the legal process to generate media attention, asserting that plaintiff's counsel seeking only to benefit himself, also describing plaintiff's counsel as willing to blatantly violate the core of ethical obligation of all attorneys and requesting a hearing on a motion the following day. Carter's lawyer's relentless filing of combative motions containing inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his clients. So, in other words, boy, bye. We are not fast tracking nothing, and anything that you're saying about the Jane Doe's attorney, I'm not trying to hear that. You need to put forth stuff for the evidence, and don't do that. Basically, what she's saying is don't do that. Don't do that. And it says here requesting the shortening of a deadline from 21 days to 1 day. So I guess when he files a motion, they have up to 21 days to look over it and do whatever they need to do. Moreover, although Carter's attorneys assails plaintiff lawyers as having a chronic inability to follow the rules, Carter's counsel has failed to abide by this court's clear rules. Under the court's individual practice in civil cases, and with limited exceptions, pre-motion letters is required prior to the filing of any motion. Although Carter's attorney stated that he intended to file immediately a motion to strike the First Amendment complaint under Rule 12F, he did not give plaintiff the requisite 5 business days to respond. So, see individual practices, or wait for the court to set a motion schedule, or state whether an exception to the court's individual practice applied. Da 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 da. She basically said this is unacceptable. Counsel is hereby advised that any further motions filed in violation of the court's individual practice may be denied on that ground alone. So, in other words, you keep filing all these things and not following the proper rules and regulations your doggone self. I'm just going to deny him on the basis of that. Lastly, although Carter's attorneys is entitled to file a Rule 11 motion without first seeking leave of court, if he still intends to serve plaintiff with a motion for sanction, the court denies his request to shorten the safe harbor provision contained within Rule 11C2 from 21 days to 1 day. So, in other words, he's going to have to file something. He is going to have to wait 21 days. Carter's motion to strike the amended complaint under Rule 12F is denied. By January 10th, the plaintiff shall file her response to Carter's motion for any order directing the preservation of evidence. By January 17th, Carter shall file his reply, if any. So, in other words, she's telling you, Judge Torres is saying, we're going to pump all of this back and forth, because remember I told you it was just a litany. They just playing ball, pow, 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 pow. Judge Carter says no. See, I'm going to give the plaintiff January 10th about this order to preservation of evidence, and then by January 17th, you should file your reply anyway. So we're going to do this properly, and we're going to be quite organized when we do what we say we're going to do here. The judge says you are not going to the judge says you are not going to upend my court, this court of law. You're not fixing to do any of that. You're going to sit here and we're going to follow these rules, and we're going to continue. So This is a setback for Jay-Z's camp. They're just going to have to, I know that they were wanting to see if they could get this see if they can get themselves dismissed from the case, but the judge says no, 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 no. The judge says no, 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 no. So what do you all think about this? So we have let me go back and see what she said again. So January 10th is the next time that they're going to be in court. Well, that's when the plaintiffs are to file a response to the preservation of evidence. And January 17th is when Jay-Z's team has the right to respond to that. The judge says your billions don't mean much in here today. I done have to come off Christmas break to set y'all in order. Wow, 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 wow. All right. And how about Spiro? He's almost like spreading himself too thin. He's got Eric Adams. He's got Jay-Z. I think his law firm has Diddy. Wow, that's a lot. Anyway, but I'm quite sure that he's getting paid the big bucks for all of this. What do you all think about this? Again, I said I was going to come back and let y'all know when I know something. Child, this is going to be back and forth, back and forth, back and forth. Also, I understand that Diddy has some new cases that are against him, and they are not filed by I know I read one that was a couple of them that were filed by a New York attorney. So he's got several new cases on that. Basically with Diddy, we gonna have to, at this point, he week to week is too much, and then to continue to be in that stuff about what they're saying is too much. We'd have to probably do that, wait to the end of the week and then go over all of that information, because that's just too much. Let's see, let's see. I'm still thinking if there's anything else. There's not anything else. Oh, I don't think I want to do this in a separate live, but apparently, Milagro, you know that what's her name? Megan the Stallion is suing Milagro, the blogger, in regards to defamation and what have you. Apparently, she has filed a motion. Let me see if I can find it. She has filed a motion to dismiss, and we see it here. This was I got this off of X. Here is the motion. Let me see. It's 21 pages. I'm not going to read it all, but let's just see. She's just defendant Milagro Elizabeth Cooper, through undersigned counsel pursuant to Rule 12B, files this motion to dismiss plaintiff First Amendment complaint. And in support therein states the following. And I think she's going to go in, but let's see if we can get down to what the. Yes, she says on these counts, basically Milagro says on count one that Megan Pete fails to state the claim for defamation. Plaintiff's failure to comply with the requirements of Florida statute 77.01 that requires that the count one be dismissed. She's saying, having abandoned her attempt to bring a claim for invasion of privacy, a legal theory not recognized in Florida for over 15 years, plaintiff now attempts to bring a claim for defamation per se against the defendant based on various statements made by defendant on various online platforms. In this diversity action, the substantive law of Florida applies to plaintiff's defamation claim as well as her other tort and statutory claims, and they list the court cases. Defendant submits that the count one of the amended complaint should be dismissed for two reasons. One, plaintiff's failure to provide defendant with pre-suit notice per Florida statute, and two, plaintiff's failure to allege a plausible claim of defamation against a public figure. Defendant will address each one in turn. B, plaintiff's amended complaint fails to allege a plausible claim for defamation of a public figure as a matter of law. Let's keep going. and it's not the whole thing, but as you could see that there was just several different things. I'm not going to pull up that lawsuit or anything like that, but I did want to just let you all know that Milagro has filed a motion with Florida court to have the case dismissed. All right, people. We do this every week. Y'all, please like, comment, and subscribe. Please share this video if you care. Y'all, please tell a friend, tell a kin, tell a coworker, tell that heifer that you cannot stand that I'm over here making these videos. And as always, people, bye-bye. Ooh, child. These court hearings are a mess. Got Jay-Z's lawyers talking crazy. You got back and forth with Milagro and what's her name? Meg the Stallion's lawyers. You got too much stuff going on, child. And I don't know where the ending is going to come here. Ooh, 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 ooh. All right, people. Bye-bye. And make sure y'all hit that like button for me. Thank you.